Good morning, Your Worship.
Morning, Mr. Baba. Mr. Highlands.
May we proceed?
We may proceed, please.
Thank you, Your Worship. The State calls case number 3246 of 2018. The State versus Duduzane Zuma, today being the 12th of July 2019. The appearance was as before. The matter has been adjourned today for judgment.
Thank you. Mr. Zuma, for the duration of the judgment, you may be seated. Thank you. Yes, the accused before court, Mr. Duduzane Zuma, appears before court charged with one count of culpable homicide arising from driving of a motor vehicle, an alternative count of contravening the provisions of Section 63, subsection 1, read with Sections 1, Section 63, subsection 2, subsection 3, Section 69, 73, and 89 of the Road Traffic Act, number 93 of 1996, that is negligent driving. He is a 38-year-old African male person. He appears represented by Mr. Helens SC, assisted by Mr. Jubber SC. The two senior counsels are instructed by Mr. Krause from BDK Attorneys. The prosecution is conducted by Mr. Baba. The state alleges that Mr. Zuma is guilty of the offense of culpable homicide in that on the 1st February 2014, he wrongfully and unlawfully drove his motor vehicle Porsche 911 sedan with registration numbers ZJF513GP unlawfully and negligently and caused the death of Ms. Phumzile Dube, alternatively that he drove the said vehicle negligently. The charge sheet was supplemented by further particulars requested by the accused in terms of Section 87 of the Criminal Procedure Act. In terms of the further particulars supplied by the state, there are four grounds on which it was alleged that Mr. Zuma was negligent, and these are: 1, he failed to keep a proper lookout; 2, that he failed to keep his vehicle under control; 3, he failed to maintain adequate control; and 4, that he failed to alter his driving sufficiently or at all to cater for the prevailing conditions at a time. The accused pleaded not guilty to both the main and alternative count. He tendered a comprehensive explanation of plea in terms of Section 112, subsection 2 of the Criminal Procedure Act, and also made admissions in terms of Section 220 of the same Act. This led to the narrowing of issues between the state and the defense. The issue of negligence was pertinently denied and put to the state to prove. It is perhaps apposite at this stage to quote the plea explanation in its entirety, and I proceed to do that. On the 1st of February 2014, I was traveling in a motor vehicle with the registration number ZJP513GP in a southerly direction on the M1 South Highway, near the on-ramp on the M1 South, situated near Gresham Drive. The vehicle I was driving was a Porsche 911 Turbo 2007 model. I had come from the Four Ways area and I was traveling in a southerly direction in the right-hand lane of the said highway. It had been raining on that evening, at times moderately and at times heavily. The road was wet. Soon after the Greyston off-ramp, my vehicle hit a pool of water and I lost control of my vehicle. My vehicle got out of control and veered across the highway and struck something. It then spun and came to a rest facing in a northerly direction. That which it made contact with was another vehicle, a minibus taxi containing a number of passengers. That minibus taxi had the registration number NWP 736GP. The sole cause of the collision between my vehicle and the minibus taxi was the fact that my vehicle aquaplaned or hydroplaned on the pool of water. Due to the rainy condition and a subsequent reduced visibility, I didn't see the pool of water. It was approximately 2200 hours in the evening. I didn't see, and I believe it could not be reasonably expected of me to have foreseen that there would be a pool of water on a national highway. Subsequent to that, independent investigation have indicated that the gradient or slope in the area in which I struck the pool of water is inadequate to handle the offlow of water from the road surface in that area, and consequently leads to a puddle or pool forming. Whatever caused the pooling of water, it was there and unforeseeably there. Although I didn't know it at the time and could not reasonably have been expected to know this or foreseen this, I caused investigation to be undertaken as to the handling capabilities of a POSH 911 table, and it has now been established that the type of vehicle is prone to hydroplane and or aquaplane more easily than other vehicles due to its light weight, wide tires, and positioning of the engine at the rear of the vehicle. I didn't know this at the time, nor could I have been expected to know that I was driving a vehicle which had a propensity to hydroplane and or aquaplane. In fact, the research I have caused to be conducted now demonstrates that the manufacturer of POSH 911 turbo vehicles have introduced a so-called wet mode in an attempt to counteract the design fault found retrospective to exist, in particular in a POSH 911 turbo. A passenger in the vehicle, Ms. Pumzile Dube, died as a result of injuries sustained in the collision. That is end of the plea explanation. In terms of the provision of Section 220 of the CPA, the accused also made a number of admissions which relieved the state from leading evidence regarding such admitted facts. In particular, Mr. Zuma admitted that the chain of evidence, including the identity of the deceased and also the result of the post-mortem report, including the finding of the cause of death. By consent, the following exhibits were handed into evidence. The post-mortem report was handed and marked as Exhibit F. In addition, the photo album was also handed. There are a number of photos which were taken during the investigation. In particular, in the course of this judgment, the court will come back to deal with photos 1, 2, 3, 1, 8, 6, 9, 12, 13, 16, and 20. The photo album contains photos clear and vivid and gives a vivid picture of the scene where the collision took place. The picture clearly depicts the scene, in particular that the N1 South motorway has 4 lanes. The photos also clearly shows the damages caused to both vehicles as a result of the collision. The layout is clearly shown in photos 1, 1A, and 2. Photo 9 shows the damage to the front side fender and the damage to the front right wheel, and also the front bumper of the minibus is removed. The same damage can be seen in photo 13 from close range. Photo 16, 17, 18, and 19 shows the damages on the POSH vehicle. There is damage on the right front corner, on the left front corner of the vehicle, as well as the damage to the rear bumper on the corner, also on the left. As indicated above, the accused tendered a detailed plea explanation, which in essence amount to that this was an incident of aquaplaning, hydroplaning, and as a result of his vehicle hitting a puddle of water. He states in his plea explanation that he lost control and this led to a collision with the minibus and therefore denying negligence. The common cause facts established are the following: which were a common cause through the admission made by the accused, as well as evidence which was led on behalf of both the state and the defense. 1, it is common cause that incident happened on the 1st of February 2014 at around 2200 hours. 2, that the collision happened between the vehicle POSH 911 with registration ZYP513GP, driven by the accused Mr. Zuma, and Toyota Hi-Ace minibus bearing registration number NWP376GP, driven by Mr. Dlamini, who testified as the second state witness before this court. That the minibus operated as a taxi and on that day had a full complement of 14 passengers. That the collision between the two vehicles happened on the N1 South near the Greyston off-ramp. That as a result of the collision between the two vehicles, there were injuries sustained by some of the passengers, and that there was also a fatality in in that one Ms. Pumzile Dube lost her life. According to the post-mortem report, the cause of death was as a result of multiple blunt force injuries. The post-mortem findings were that there were extensive blunt force trauma causing cerebral injuries, injuries to the internal organs of the chest and abdomen, and multiple fractures. Another passenger who was injured during this accident later lost her life. The name of the deceased of that passenger was Lynette Mashaba. It appears from the medical report handed that she also sustained severe physical injuries. The medical form, that is Form J88, records that among some of the injuries she suffered was tenderness over right chest side with palpable rib fractures of rib number 4, 5, 6, 7, and 8, and blood in the chest cavity. And also there was a bloody discharge from the right nostril and head injuries. The CT scan showed subarachnoid hemorrhage and subdural hemorrhage. The conclusion by the medical doctor was that the injuries were in keeping with the sustained by motor vehicle accident. It is also common cause there was also another passenger, namely Charlotte Ndlangize, who also sustained injuries. She testified in this court as witness number 5 for the prosecution. According to the medical report, which was handed as Exhibit D, she sustained abrasion on the right arm and had right proximal radial fracture. That also it is common cause that there had been a period of sustained rainfall which resulted in a water forming across the highway. There were periods when it rained moderately and periods when it rained heavily. As a result, there was reduced visibility. It is also common cause that the vehicles were traveling from 4 ways and towards a southerly direction on the M1 South. State led the evidence of 6 witnesses, and this included Mr. Ngumalo. He is employed by South African Weather Services as a climatologist, and he testified about the rainfall measurement which was recorded during that period from a weather depot in Alexander, which is some 3.9 kilometers away. He explained different types of measuring rain, and in particular made reference to what he referred to as the tipping basket system. As a climatologist, he was not prepared to commit himself whether he could say if it rained heavily or not on that day in question. He considered under cross-examination that rain falling any distance away from the station may be totally different from what is measured by that weather station, especially since rainfall can vary significantly with space and time. Given the testimony of both the state witnesses and the defense, not much turns on the evidence of Mr. Ngumalo. The condition of the road and the severity or otherwise of the rainfall became common cause during the trial. The evidence of Mr. Ngumalo didn't take the matter any further. The state also led the evidence of Mr. Kronje, the principal dealer at Post Johannesburg. He testified, among other things, about the service history of the vehicle during the period in question, and also about certain specifications of a Porsche car. He testified that the vehicle was last serviced on the 26th November 2013 before the incident of the 1st of February 2014. He gave a detailed account of the service that was undertaken, also handed in the invoices in respect of the said motor vehicle. Prior that date, the vehicle was taken for service on the 27th September 2013. The former service was overheating, and the latter service was for squeaking brakes. He further testified about some safety features, including the fact that the Porsche vehicle is fitted with ABS braking system, and also that the brakes are also made of steel. In respect of how the vehicle will behave if it hit a puddle of water, he indicated that it depends on the situation. There will be so many factors at play that he will not be able to answer that directly. He was not prepared to speculate on a number of scenarios that were given to him by the state, especially around traction management system and stability management unit. It is also worth mentioning that the evidence of Mr. Kronje regarding his own experience regarding a Porsche. He testified that he once experienced aquaplaning, though his vehicle did not veer off or change direction, but it kept driving straight. He added a rider that, and I quote, "I must say, not due to anything that I did not do, as I didn't feel out of control," end quote. He confirmed that in that situation, he was not in control of his vehicle, though the vehicle didn't spin. He again added that it was not because of what he did nor didn't do. In cross-examination, Mr. Ronye revealed that his vehicle aquaplaned at a speed of between 70 and 80 kilometers per hour, and that he didn't see the puddle of water before he hit it. The incident he referred to also happened at night. He was also asked by a new feature that the Porsche manufacturer intended to add a safety enhancement in the new models, which is referred to as wet mode. In particular, Mr. Kronje did consider Porsche vehicles of the type driven by Mr. Zuma on that day in question were prone to aquaplaning. The state also called a third witness, Mr. Dlamini, who was the driver of the minibus taxi. He confirmed that he had a full complement of passengers, that is 14 passengers in the minibus taxi, and that he drove from 4 ways on the N1 South and then joined the N1 South. He indicated there was inclement weather and that it was raining a bit from when he started his journey. It was when he was on the N1 South around Marlborough on off-ramp that the rainfall increased. Despite this, he testified that his visibility was minimally obscured to a distance of between 3 to 4 vehicles ahead of him. He testified that there was minimal vehicular traffic and also described the mood in the taxi as jovial and that they were even playing music. He didn't see the Porsche vehicle at any stage before the collision. He testified that given the condition of the road and because of a lot of flowing water, he reduced speed. He indicated that there was a lot of water because in the area of Marlborough Drive there is a descent and some of the water, and I quote, did not flow into the drain, so there was a build-up of a lot of water, end quote. Mr. Dlamini further revealed that he was alerted to a vehicle by one of his passengers but couldn't see this vehicle until after the collision. During cross-examination, Mr. Dlamini indicated that he reduced his speed from 100 kilometers or possibly lesser because of the rain. Importantly, he considered that as an inexperienced driver, he felt that a speed of between 90 and 100 kilometers per hour was a safe decision to maintain for anyone using that road as the correct speed to drive despite the prevailing weather conditions. The next witness called by the state was Ms. Matron Madikani. She was a passenger in the taxi. She also testified that it was raining. She further described what she saw as follows, and I quote, "Then a black motor vehicle appeared. It seemed as if it was traveling across the road. I then shouted out to the driver, asking him if he can see this motor vehicle. It seems as if it was going to injure us. The driver then agreed and said yes. This motor vehicle came past just for a short while. After it had passed, it then turned around. This motor vehicle spun and then was traveling on reverse. As it approached, it collided onto the taxi," end quote. She further testified that she saw the black car spin but didn't see or experience the taxi spin. After the collision, she described the position she found both Mrs. Mashaba and Ms. Dube and also indicated she's the person who performed the ritual of closing of the eyes of the deceased Ms. Dube. In respect of speed, she testified that the car that collided with the vehicle was driving fast as it overtook them and then spun and reversed into their taxi. She denied that the taxi was speeding. Ms. Charlotte Langize also testified she was also a passenger in a taxi driven by Mr. Dlamini. She confirmed that it was raining on the night of the collision and that the said collision happened on N1 South at around 2200 hours. She only saw the taxi spinning and faced the direction it came from, and also that the taxi nearly fell over. She testified about the conditions she found both her fellow passengers, namely Ms. Mashaba and Ms. Dube, after the collision. According to her, they were both hanging over outside the windows of the taxi. Ms. Ndlangiza was also injured and was assisted by the accused Mr. Zuma, who took her into his car until the ambulance arrived. She didn't hear anybody alert the driver to the impending collision. She testified that until the following day at the hospital, she didn't know which vehicle collided with the taxi she was traveling in. According to her testimony, and I quote, the taxi, she felt a knock on the right-hand side. The last witness for the state was Mr. Johan Hendrikus van Locherenburg. He was at the time employed by Johannesburg Metro Police Department, JMPD. He explained his qualification and the role he played after he was called to the scene on the night of the incident. He explained the routine he performs when he arrived at motor vehicle accident scenes. He took photos of the scene, the vehicles, the road, the injuries, the injured people, as well as the deceased person. He also drew a sketch plan, a rough sketch plan of the scene, and thereafter also obtained names and addresses of the witnesses as part of his investigation. He confirmed that he completed the accident report form based on the information obtained from both drivers, that is Mr. Dlamini and Mr. Zuma. He further testified about the scene as he found it, and in particular that the vehicles were still at the scene. He arrived just before midnight at 23:55. He confirmed that both drivers were licensed. He testified that upon his arrival at the scene, at that time he could find no still standing water on the road surface. He could also not find that the vehicle or the road may have contributed to the accident. It was almost 2 hours after the incident. He thus submitted human error may, and I quote, may have contributed to the accident. He explained that the vehicle is driven by a human being and can only be that the human being may have made an incorrect decision and taken an incorrect action, and thus the vehicle resulted in an accident. He confirmed that Mr. Zuma told him that he hit a puddle of water. Mr. Locherenburg added that given the prevailing condition at the time of the collision, a driver should first of all reduce the speed tremendously and keep a proper lookout on the road. And if the vehicle doesn't go into a skid, whatever the driver has done, and if the vehicle does go into a skid, whatever the driver has done, he must correct that by releasing the brake, releasing the accelerator, and just concentrate on steering and keeping the vehicle in a straight line. In response to the plea of Mr. Zuma that he went in a pool of water and as a result his vehicle aquaplaned, Mr. Locherenburg responded that aquaplaning is a phenomenon where a wall of water is in front of a tire, and because of poor tire condition, which might be smooth, the driver will get the feeling that he's actually traveling on top of the water. He however considered that the tires of the Porsche vehicle were measured, and the measurement showed 5 centimeters, which, according to him, was within the legal limit. During cross-examination, he was asked about what should be the response of the driver when faced with an unexpected situation in the condition experienced on the night in question by Mr. Zuma, and he replied that the driver must be alert. Mr. Locherenburg was cross-examined at length on a joint minute which he helped prepare with Mr. J.P. Stroudum. Mr. Stroudum was an expert called during the inquest proceedings. The joint minute was handed and marked as Exhibit O into the record. It didn't appear to be differing in any material way to the stated facts and conclusions in the minute. He considered and agreed that the tire measurements met the legal requirement, and also agreed that aquaplaning could not be ruled out. Mr. Locherenburg further accepted as, and I quote, absolutely true, the defense proposition that speed is always a factor when it comes to aquaplaning, and further that should it happen that one aquaplanes, then it does not necessarily imply that the driver was speeding, that is, exceeding the speed limit. Aquaplaning can happen well within the road's maximum speed limit, and further that no driver will know what the right speed is to drive at in order to prevent aquaplaning. He confirmed under cross-examination that he could not dispute or deny that the accused was traveling between 90 and 100 kilometers per hour, and that it was a safe distance in those conditions for any reasonable driver driving carefully at a time on a national road. Mr. van Logerenberg admitted that it will be difficult for any ordinary driver to see a puddle of water which may have formed on the national road. After this evidence, the state closed its case and the defense applied for a discharge in terms of Section 174 of the Criminal Procedure Act. The application was unsuccessful and the defense opened its case and called the accused Mr. Zuma to testify, and he amplified his Section 115 statement under oath. He confirmed that he was the driver of the Porsche motor vehicle and that it was raining with wet road surface, and he was initially driving at a speed of around 120 kilometers per hour when he left four ways, and that he went into a puddle of water and he lost control of his vehicle. He indicated that at that point he didn't apply brakes, nor did he accelerate. He only held on to the steering wheel. He testified that he held on to the steering wheel and the vehicle started to spin and he collided with something. The vehicle eventually came to a stop, and at that stage it was in the middle of the road, and he took a decision to move the vehicle out of harm's way. Mr. Zuma testified I didn't see a pool of water before he went to such a pool of water. He further testified that on the as a result of this accident, he caused an investigation to be done regarding the handling capabilities of a Porsche 911, and it has since been established that the said vehicle is prone to aquaplaning. He testified that given the condition of the road on that day, it was impossible that he could have seen a pool of water on the road. He testified that he uses the road frequently and he has never noticed a pool of water on that stretch of road. He testified that in his perspective, it was impossible to avoid what had happened on that evening. Mr. Zuma confirmed that at the start of his journey from Mofwe, where he was driving at 120 and he reduced the speed. He also experienced diminished visibility as cars traveling on his left side sprayed water on his vehicle. He reduced the speed to between 90 and 100 on his estimation. He testified that as the weather progressively worsened, his eyes were focused on the road and not on the dashboard. In cross-examination, Mr. Zuma considered that he could not remember the exact last time he changed his tires of his Porsche. He was insistent that the tires he had on his vehicle were able to handle the rain. He estimated the time as between 3 to 5 months prior to the accident. In his words, the tires were relatively new. In respect of visibility, estimated that he could probably see the distance of anything between 10 and 15 meters ahead of him. Mr. Zuma described the duties of a driver as being to always be observant, to have a look out for the surroundings, and to drive cautiously and carefully, and to keep every other road user in mind. He maintained that given the prevailing circumstances in relation to the flow of the traffic, the trend of the movement of the vehicles, and given how some were moving at the same speed and as vehicle and others less and some more, he concluded it was more than reasonable at that point for him to be driving at that speed. He maintained during cross-examination that given the prevailing condition, the speed of 90 and 100 was reasonable. This was based on his assertion that, and I quote, on an open highway, wide lanes, you do not expect to see any standing water, end quote. He considered that he gave different speed estimates to the police when they obtained a warning statement, and also to the assessor for the insurance purposes, and ultimately during the inquest proceedings. He estimated the speed at 70 kilometers per hour to the insurance assessor. The second defense witness was Mr. Conrad Luther. It was not disputed that he was giving expert evidence, and he was indeed an expert. He indicated that he was a mechanical engineer and he practiced as a forensic engineer. Specifically, his expertise is in the field of accident reconstruction, and that will include anything that is mechanically engineering related. He also that includes rail accidents, aircraft accidents, and industrial accidents. So it is anything that might be mechanically engineering related, as I've already mentioned. He mentioned his extensive experience where he was involved with accident reconstruction. He was involved in the investigation for approximately 1,000 tire failures and about 500 reports written about tires. He also testified about tire technology course that he underwent. He testified that it was a cause relating to that which is also related to the investigation of tire failures. That also includes aspects such as tire thread design, how it works, why threads are designed in a certain way. So a reasonably broad scope in that specific cause, but it was mainly related to the purpose of tire investigation that failed or allegedly failed. He compiled a report about the accident in question. The report was handed and marked as Exhibit R. He testified that due to the nature of the incident, he was asked to determine from the information available whether the Porsche had been driving at an excessive speed at the time of the accident. He was therefore asked to calculate the possible speed or speeds of the vehicles based on the distance as determined by the investigators. Mr. Lotter, in conclusion, allied himself with Exhibit O, that is the joint minute, that the two vehicles must have been traveling at more or less the same speed. He further disputed the evidence of Mr. van Logerenberg regarding the possible point of impact. He testified that the accused vehicle traveled more or less the same speed as the minibus. In terms of his conclusion, the accused vehicle was not speeding and didn't pass the minibus. According to his conclusion, otherwise it would have missed the minibus if it was driving fast. According to his conclusion, the accused vehicle could not have been airborne at any stage, and further the Porsche hit the minibus at the right hand front side, which caused the minibus to spin. Mr. Lotter testified at length regarding what he thought was the probable point of impact of the two vehicles. There was reference to photo album as well as the photos of the minibus, which he retrieved from internet during his investigation. He concluded that the damage shown by photos 6 and 12 on the minibus, which are on the right rear corner stretching from the rear right light up to the window, could not have been caused by the collision with the Porsche. According to him, the conclusion is based on the, and I quote, significant tears of the metal at that area, which absolutely does not match the fender on the Porsche. According to the conclusion of Mr. Lotter, the damage was caused by a secondary collision when the vehicle collided with a guardrail as it was spinning. He concluded that there was a glassing contact with a minimum deformation, and it was also reasonable to state that both vehicles would have maintained most of, if not all of, their pre-impact momentum. They were essentially traveling in the same direction, so it is not a situation of two vehicles that collide head-on as they lose speed. The following point was made that in relation to the calculation of the speed of the distance, it is firstly evident that neither of the vehicles was traveling at an excessive speed. It is also evident from the location of the vehicles close to each other at the final position of rest and from the minimal impact of the two vehicles that there was not a speed differential between the two vehicles. Mr. Luther also dealt at length in his report and testimony about aquaplaning. He listed a number of factors that may lead to this phenomenon, and this being the inflation of the tires, the effect of the footprint aspect ratio, the effect of the load on the vehicle, the effect of the water film thickness on road surface, the thread depth of the tire, and the speed of the vehicles. He indicated a number of factors that play a role in the possibility of aquaplaning occurring, and that all these factors are interrelated and really complex and may lead to a situation where a vehicle may in fact aquaplane at a very low speed. He testified that under certain circumstances it may even occur speed below 70 kilometers per hour. In this specific case, it was indicated that the vehicle made contact with water that pooled on the road surface, which may have been related to the slopes and the general drainage in the area. In such circumstances, as indicated, if the water film exceeded merely 5 millimeters above the road asperities, the tires could have behaved similar to slick tires due to the presence of excess water, which would have been the major factor. Added to this, the Porsche, according to him, is a relatively light sport vehicle that also have tires with a large footprint aspect ratio, which will make it more likely to aquaplane. In cross-examination, the state dealt at length with one of the factors mentioned by Mr. Lotter, namely depth of tires and the manufacturer's specification regarding tires of particular vehicle models. The response by Mr. Lotter was that a vehicle is designed in cooperation with tire manufacturers, and that is the most suitable to that particular car manufacturer, but it's no fault to use other type of tires. The last witness called by the defense was Mr. Robert Jankelovitz. He described himself as a sport car fanatic, so any sport car that does pass him or that he sees on the road, he takes careful note of and he appreciates those vehicles. So the car did not pass him about 5 kilometers, did pass him about 5 kilometers prior to that to the accident on the right hand side. He described the condition as being bad. In his words, the visibility was very bad that night and could not even see approximately 4 or 5 cars ahead of him. What he was doing was basically guiding himself by the brake lights and the lights of the other vehicles in front of him, and it was impossible to even see the white lines on the road. According to him, everybody that was driving along him was not driving excessively, including those that were passing and those that he was passing. In respect of Mr. Zuma, he testified that the Porsche was not speeding when it drove past him. According to him, the vehicle was certainly not driving excessively at all, in his opinion, as he was able to even see the plate numbers and know that, and he thought that the car was an older model given the registration sequence of the GP numbers that he saw. And he indicated that he could actually see the nameplates and the number plates and see the vehicle passing. He was insistent that he was able to properly see the vehicle as it was not speeding. He went on to explain the cautionary step that he took after he had observed that the vehicle had spun when he arrived at the scene. This he concluded by the lights that appeared to be on his drive path. Upon arriving near the scene of the accident, he was able to see that it was the same Porsche vehicle that had passed him some 5 kilometers earlier, as per his estimation. Upon seeing the damage to the vehicle, he gained the impression that it was a mere bumper bash, though he remarked to his fellow travelers that it was going to cost, and I quote, the owner a packet. He also explained that for the reason that he had the matter discussed on news broadcasts, where it was alleged that the Porsche was speeding, he wanted to set the record straight, but was rebuffed by DJ on duty at a named radio station. He subsequently contacted the attorney for Mr. Zuma when he learned that there were steps to pursue private prosecution. Now, the issue before court. In the light of the plea explanation proffered, the court is required to make a finding whether, 1, the driver of the Porsche, namely Mr. Zuma, drove his vehicle negligently on the day in question, given the prevailing circumstances, whether such negligence, if any, caused the death of the deceased. Now, I'll proceed to evaluation of the evidence as I have outlined. As indicated at the beginning of the judgment, there are facts that did not occupy this court for a long time, lest the judgment becomes unduly long. The evidence between the state regarding the condition of the road on the night in question, and also that it was raining heavily immediately before the collision, is common cause and is found to be proved. The evidence of the Ngumalo regarding the amount of rain experienced on the night in question didn't take the matter further, as I've indicated, especially that on his own admission, it would be difficult to use evidence of rain collected in either weather depot some 3.5 kilometers away to determine the amount of rain at the place of the collision. The analysis of the evidence of Mr. Dlamini reveals that he did little to assist the court. He didn't see the vehicle that knocked his vehicle. According to him, he heard a voice from one of his passengers that there was a vehicle veering towards them and he was about to collide with his vehicle. There was no preventative steps that he took to avoid collision. He didn't see the vehicle that collided with his minibus. It is not clear why he lost consciousness. The issue was not pursued further by the state. Despite alleging that he looked to see the vehicle, he saw nothing and subsequently lost consciousness, as I have indicated. Except to confirm that it was raining and that he reduced his speed to between 90 to 100 kilometers, there is not much turning on his evidence to assist this court in the determination of the guilt or otherwise of Mr. Zuma. He never saw the vehicle of Mr. Zuma prior to the collision. He even failed to inform the court about any vehicular traffic on this day or this night. The reason he reduced speed was because of the prevailing condition. He considered that such speed reasonable in view of the prevailing circumstances. I must therefore conclude that there was never a stage that the vehicle of the accused was ever in front of his vehicle, at least not before the collision. He said that he saw lights on his mirror which must quite clearly support the contention that the Porsche was never ahead of him prior to the collision. Ms. Matron Madikani is the only witness who testified that he saw the vehicle of Mr. Zuma moments before the collision. She testified that the vehicle veered towards the path of the taxi and then went past it and collided with their vehicle as it reversed towards their vehicle. As she observed what was unfolding in front of her, she shouted to Mr. Dlamini to alert him of what she thought was an impending danger. According to her, Mr. Dlamini indicated that he could see the vehicle. It should be indicated this contradicts Mr. Dlamini's testimony that he acknowledged her caution by indicating that he could see the vehicle. The evidence of Ms. Madikani must also be taken in the context of where she was seated in the taxi. According to her, she was seated towards the left on the seat behind the driver. There were two other passengers to her right. The vehicle came from the right of the minibus. While the court accepts that she was of a mature age of 73 years of age and also that the accident must have had a traumatic experience on her, she was not a model of a good witness. She was a difficult witness, especially under cross-examination, and refused to answer some questions. This led to the court intervening to indicate to her the importance of answering questions under cross-examination. She couldn't tell why the driver could have failed to see the vehicle, which according to her went in front of their vehicle and reversed and collided with their vehicle. Despite being projected as a very good witness by the state, this court doesn't share that view. I agree with the defense submission that she had a fleeting, and I quote, a fleeting glance of the accident. Ms. Ntlangize didn't advance the state case any further. She was one of the 14 passengers in the bus of Mr. Dlamini. She didn't see the vehicle that collided with her taxi and gained that knowledge some days later whilst admitted at hospital. She, however, confirmed that after the collision, the minibus spun and nearly tipped over. She confirmed her injuries as reflected on the JAD. She made a point that she felt a knock sound from the right side of the minibus. The evidence of Mr. Kronje essentially confirmed the version of the accused. The same can be said of Mr. Jankelovic. In his closing argument, the prosecution admitted that it didn't attempt to discredit him. The evidence of Mr. Jankelovic must therefore be taken as unchallenged, and therefore the court relied on its cogency. The state accepts that he had a clear view of the accused vehicle, and this should mean that the court can rely on his testimony in this respect. This will include accepting his observation that the Porsche drove past him driving at a speed he didn't consider excessive. The argument as to how his version corroborates the version testified to by Ms. Madikani as argued by the state escapes me. Now, the court has decided to deal and analyze the evidence of the two expert witnesses together. This is purely because the evidence of the two doesn't mutually exclude each other. The two witnesses are an idiom that aquaplaning is a phenomenon that can be expected in the type of weather that was prevailing on that day. Mr. Van Logremer didn't disassociate himself from the conclusion of Exhibit O, that is the joint minute. He admitted that there was no standing water on the road when he arrived at the scene. In the joint minute, he agreed with the statement that, and I quote, the fact that he could not find still standing water on the road surface does not mean that there could not have been at least a volume of amassed water on the road surface at the time of the collision, end quote. And crucially, according to the joint minute, it is noted that, and I quote, further agrees that aquaplaning cannot be ruled out, end quote. Mr. Van Logrenberg repeated that concession during testimony. The evidence of of Mr. Luther was not meaningfully challenged. He concluded that the vehicles must have been traveling at the same speed. He concluded that the damage on both the right rear portion of the minibus and the front side were secondary damages were caused by the minibus when it hit the guardrail after it collided on the side with the Porsche driven by Mr. Zuma. The manner of dealing with expert evidence was explained as follows by in the case of Michael and another versus Linksfield Park Clinic, Pty Ltd, and another ZASC A12, where it is stated, and I quote, "It is perhaps as well to re-emphasize that question of reasonableness and negligence is one of the court itself to determine on the basis of the various and often conflicting expert opinion presented." And further, the court continued to state as follows at paragraph 13. As a rule, the determination will not involve considerations of credibility, but rather the examination of opinion and analysis of the essential reasoning, preparatory to the court reaching its own conclusion on the issues raised, end quote. This approach was also endorsed in the case of Opelt versus Health Department of Health Provincial Administration, Western Cape, where the court stated, and I quote, that being so, what is required in evaluation of such evidence, meaning the expert evidence, is to determine whether and to what extent the opinion advanced are founded on logical reasoning, end quote. During this trial, a number of journals and articles were also placed before this court. This was mainly regarding what was described as propensity of the Porsche 911 to aquaplane and hydroplane. The expert didn't directly contradict the content of such articles and journals. The two experts were in agreement that aquaplaning could have happened as described by Mr. Zuma, both in his plea explanation and testimony. I indicated I shall return to deal with the photos and the conclusions reached by Mr. van Logrenberg. He concluded that damage to the right front corner depicted in page, the left front corner depicted in page 20 on the Porsche was caused when it collided with the minibus as depicted in photos 6 and 12. The damage on the minibus extended from immediately above the bumper until at the start of the rear right window. He indicated that according to his conclusion, the damage was on the upward trajectory. In respect of the damage on the right side of the vehicle as depicted in page 13, Mr. van Logrenberg concluded that will be from an impact either with a barrier or a curb along the side of the road. In cross-examination, Mr. Logrenberg considered that the damage on the minibus was high, that is photo 6 and 12, and that the Porsche was a low-slung car. While he was insistent that the damage at the back of the minibus was caused by the collision with the Porsche, when pressed to substantiate his assertion, he couldn't. He considered he had no basis to come to that conclusion. In conclusion, on the probabilities, the court is not satisfied that reliance can be placed on the conclusion reached by Mr. van Logrenberg in explaining the damages. The probabilities are more consistent with the Porsche having knocked the minibus on its front right side with its left front corner and causing a tire burst and scraping marks which are visible in photo 13. This is consistent with the height of the front portion of the Porsche. Thereafter, the two vehicles spun and further damages were experienced, what has been referred to as secondary damages. The evidence of Mr. van Logrenberg doesn't account for all the damages to the minibus. The damages caused by the minibus colliding with the steel barrier are not accounted for in his testimony. The analysis of Mr. Zuma's evidence revealed that he was consistent both in his plea and his testimony under cross-examination. The state didn't challenge the evidence of Mr. Jangolovitz in any meaningfulness. The state appeared to have accepted his version of events. And then what does the law say? Culpable homicide consists of the unlawful and negligent causing of the death of another. The state bears the onus of proving not only that the accused was negligent, but also that such negligence caused the death of the deceased. the onus must be discharged beyond a reasonable doubt. The onus of proof in a criminal trial is discharged by the state if the evidence establishes the guilt of the accused beyond reasonable doubt. The corollary is true that he is entitled to be acquitted if it is reasonably possible that he might be innocent. In the case of State versus Van der Meyden, 1999, Volume 1, South African Criminal Law Report, page 447, in brackets W, the court stated as follows, and I quote, "In order to convict, the evidence must establish the guilt of the accused beyond reasonable doubt, which will be so only if there is at the same time no reasonable possibility that an innocent explanation should have been put forward might be true," end quote. The approach of weighing the evidence is that witnesses must be weighed and not counted. The right approach was stated as follows in the matter of State versus Cleaver 1974 3SA 844T, where Margot J. as it then was stated, the evidence must be weighed as a whole, take into account the probabilities, the reliability and opportunity for observation of the respective witnesses, the absence of interest or bias, the intrinsic merits or demerits of the testimony itself, any inconsistent contradictions, corroboration, and all other factors, end quote. In the case of R versus Mary, 1927 AD 41 at page 45 to 46, the court stated as follows regarding negligence, and I quote, "Negligence can never be disentangled from the facts, but its existence is best ascertained by applying to the facts of each case the standard of conduct which the law requires. A consideration of those and other authorities does not, I think, justify us in drawing a hard and fast distinction between negligence necessary to establish liability in civil and in criminal cases, respectively. In civil actions, we have adopted as a simple test that standard of care and skill which would be observed by a reasonable man, and it seems right as well as convenient to apply the same test in criminal trials. The difficulty of defining culpable negligence apart from such test is very great." During closing argument, the court was referred to a plethora of cases dealing with negligence. I shall make reference to a number of these cases in order to guide me in arriving at a finding. The leading case remains Kruger versus Coetzee, 1966 2428A, where Holmes J.A., as he then was stated in his iconic quote, "For the purpose of liability, culp arises if a diligence paterfamilias in the position of the defendant would foresee the reasonable possibility of his conduct injuring another in his person or property and causing him patrimonial loss, and will take reasonable steps to guard against such occurrence, and the defendant failed to do so." This has been consistently stated by this court for some 50 years. This was in 1966, so it means it's for about 90 years now. Requirement A2 is sometimes overlooked. Whether a diligent paterfamilias in the position of the person concerned will take any guarding steps at all, and if so, what steps will be reasonable, must always depend upon the particular circumstances of each case. No hard and fast basis can be laid down. Another case that I was referred to during argument is the case of State versus Bocheres Investment Pty Ltd and another, 1988 Volume 1 SA 861A, where the court stated, and I quote, "The onus of proving culpa on the state, which had to establish a failure by the accused to observe that degree of care which a reasonable man would have observed. The reasonable man is the diligence paterfamilias of Roman law, the average prudent person, that notional epitome of reasonable prudence, in the words of Holmes J.A. in Peri-Urban Areas Health Board versus Mineral. A reasonable man is the embodiment of the social judgment of the court, which applies common morality and common sense to the activities of the common man. The criterion of liability for culpa in both civil and criminal is reasonable foreseeability. In a case of culpable homicide, the question is whether a diligence paterfamilias in the position of the accused would have foreseen the possibility of death resulting from his conduct. This is also stated in State versus Berger quoted above. As per the decision of State versus Berger, culpa and enforceability are tested by reference to the standard of a diligence partus familias in the position of the person whose conduct is in question. A diligence partus familias treats life's path with moderation and prudent common sense. In State versus in a matter of Sea Harvest Corporation Pty Ltd and another versus Duncan Dock Cold Storage Pty Ltd and another, the following is stated. It should not be overlooked that in the ultimate analysis, the true criterion for determining negligence is whether in a particular circumstance the conduct complained of falls short of the standard of the reasonable person. Dividing the inquiry into various stages, however useful, is no more than an aid or guidance for resolving this issue. It is probably so that there can be no universally acceptable formula which will prove to be appropriate in every case. It has been recognized that whilst the precise or exact manner in which the harm occurs need not be foreseeable, the general manner of its occurrence must indeed be reasonably foreseeable. End quote. In the light of the decision referred to above, it is now clear that on a charge of culpable homicide, the prosecution must prove beyond reasonable doubt that a reasonable person in the position of the accused would have foreseen the possibility of death. The position of the law regarding negligence is therefore simply put the following. There are two steps. The first is foreseeability. Would a reasonable person in the position of the defendant accused foresee a reasonable possibility of injury or causing death of another? And the second is preventability. Would that person take reasonable steps to guard against the injury happening? The key point is that negligence must be evaluated in the light of the circumstances of each case. The state must therefore provide evidence of deviation from the standard of a reasonable person. The test is accused specific. That is, the evaluation must be made against the particular accused before the court. The conclusion that Mr. Zuma was negligent can only be made once the requirements stated in State versus Kruger have been complied with. The test to determine is obviously normative in character. The accused is measured against a standard out of himself, namely what a reasonable person in the same circumstances would have foreseen or done. The test requires the making of a value judgment. So on the negligence test, the first question, could the accused, that is Mr. Zuma, have reasonably foreseen the collision with the vehicle driven by Mr. Dlamini and the resultant death of Ms. Dube? The answer, whether yes or no, is dependent on the evidence placed before this court. It is to be pointed out the accused bears no onus to disprove his guilt. The onus is throughout on the state. The prevailing weather conditions as described throughout this case present a different scenario for any driver. It is, I believe, axiomatic that more caution is called for in the conditions that were explained by all the witnesses. The court concludes that the road surface was wet and resulted in slippery condition. There is ample authority for the proposition that when a driver is traveling in wet and slippery condition, he has a duty to take special care to regulate his speed and to drive in such a way as not to involve himself in a skid in this manner. See, for instance, Hammer and another versus Nunes 1976 2 SA 785 RAA at page 788, and the case is quoted therein. The totality of the evidence, that is the evidence from both the state and the defense witnesses, established that the weather condition was bad. The rainfall had resulted in reduced visibility, slippery driving condition, and a lot of water on the road surface. It is clear that this called for caution on the part of road users. The situation was exacerbated by the fact that this was at night. The reaction of Mr. Dlamini, the driver of the minibus, was to reduce speed to between 90 and 100. It must be remembered that he was driving with 14 passengers in his vehicle. The state didn't argue that this was reasonable on the part of Mr. Dlamini. According to Mr. Zuma, he also reduced speed to the same level. He was also motivated by the deteriorating driving condition and as a result of the downpour he witnessed. According to Mr. Jankelovitz, he observed the vehicle of Mr. driving past him. At that stage, Mr. Jankelovitz was also driving at a speed he thought appropriate for the prevailing condition. As the vehicle of Mr. Zuma drove past him, he could observe its make and model and number plate sequencing. He estimated his own speed at 65 kilos per hour. Joint minute by the two experts, Mr. Treumann and Van Logerenberg, which was prepared for the inquest proceeding, concluded that the driver must have been driving at the same speed at the time of the collision. The conclusion was also arrived at by Mr. Lotter, who is an accident reconstruction expert with impressive qualification in his area of specialty. The conclusion was based on the relative proximity of the two vehicles coming together to stop after the collision. This evidence, if used to measure the conduct of Mr. Zuma in the prevailing weather condition, doesn't appear to support any form of deviation from the standard of a reasonable person. The version of the state does not establish the manner in which it can be argued Mr. Zuma did not observe the standard required of his reasonableness. The court was invited by the court to draw a conclusion that the tires were not of a good standard. The statement made reference to what it was said was real evidence. The reason proffered was based on an inscription from a text invoice where it is noted that, and I quote, customer declined tires. The invitation is declined by the court for the following reasons. The two experts, as well as the assessor from the insurance company of Mr. Zuma, confirmed that the tire treads were within legal limit. According to the uncontested evidence of Mr. Zuma himself, the tires were changed 4 to 5 months prior to the accident. The invoice in question is dated 22 February 2010, which is almost a year to the date of this incident. The other invoice that noted the customer declined tires is contained in the invoice dated November 2013. The point was pertinently made by Mr. Van Logerenberg that he observed nothing from the vehicle which could have contributed to the accident except for the human error. According to Exhibit Q, which is a loss report compiled by or for the insurance company, under the heading tires, it is stated as follows. The tire threads measurements were recorded by the motor assessor as follows, and had no influence on the incident. These were Michelin 305/30Z tires. The left front was 555. The left rear, all the four tires were measured at 5 centimeters. It is important to note that the same measurements were made on invoice dated 26/11/2015, marked as Exhibit D. It is the same invoices where remark is made of Mr. Zuma's declining new tires. In the case of Hammer, quoted above, the defense of aquaplaning was rejected. The court remarked that aquaplaning does not occur as a natural phenomenon. The defense was rejected in that case as the court concluded that the vehicle concerned had smooth tires. In that case, unlike in the present matter, the expert who was called from a tire manufacturer gave testimony to that effect. In our case, the expert testified that tire treads were within the legal limit. The expert testimony placed before the court appears to support the version that, given the amount of water on the road, pooling cannot be excluded. The accused testified that he had used the said road quite frequently and could not have foreseen a puddle of water at that particular area. According to the expert, these were perfect conditions for aquaplaning to can occur. Mr. Kronje from Porsche testified about his own experience where he aquaplaned whilst driving at a speed of 70 kilometers per hour. The whole tenor of his testimony of the evidence regarding aquaplaning appears to confirm that aquaplaning can be experienced at relatively low speeds. Mr. Van Logerenberg and the joint minute makes reference to inappropriate speed. As I understand it, the issue of whether the driver, in this case Mr. Zuma, drove fast or not does not arise. At issue is whether, given the prevailing circumstances, Mr. Zuma was driving in appropriate speed. The speed can be but one of the factors to be considered. Given this, the pivotal question is the second part of the negligence test as per Kruger decision. What steps would a reasonable driver in the position of Mr. Zuma have taken to guard against a foreseeable harm? As indicated, the steps to be taken must be taken against the prevailing condition, in particular the presence of water on the road. The question of forcibility and preventable needs to be answered in this segment of the inquiry. Would a reasonable person in the position of the accused have foreseen that there will be a puddle of water on his path of travel and could cause aquaplaning and the vehicle to veer off to the left and result in the collision and the subsequent death of Mrs. Dube? If so, would a reasonable person have prevented such an occurrence from occurring? Further, a reasonable man must have foreseen a puddle of water at that. Would a reasonable man have foreseen a puddle of water at that particular area of the motorway and would have taken steps to avoid driving through it to prevent acquittal? The question should be answered by inferential reasoning based on the proof facts. It should not be based on conjecture and speculation. The evidence is that there was a lot of water on the road. It was at night and visibility was impaired. As argued by the defense, water is colorless. The speed doesn't appear to have been of any consequences given what the three drivers who testified told us. The joint minutes know that to the extent that Mr. Zuma was traveling within the permitted speed limit, one cannot necessarily conclude that he was indeed speeding, that is, meaning exceeding the permitted speed restriction for the road when he started to aquaplane, unless the evidence would suggest otherwise. As already indicated, there is no such evidence to suggest otherwise from any of the witnesses called by the state. The evidence before this court is that Mr. Zuma never executed any action which may have or resulted in vehicle veering to the left towards the minibus of Mr. Dlamini. The change of direction happened after he had lost control of the vehicle. Despite holding to the steering wheel, as he said, for dear life, he didn't perform any other act. He had no control of the vehicle until it came to stop after it had collided with the minibus. The court is required to draw inference regarding negligence. This can only happen if the test laid down in R versus Blom is satisfied, namely that reasoning by inference in a criminal case, there are two cardinal rules of logic which cannot be ignored. The first rule is that the inference sought to be drawn must be consistent with all the proof facts. If it is not, the inference cannot be drawn. The second rule is that the proof facts should be such that they exclude every reasonable inference from them save the one sought to be drawn. If these proof facts do not exclude all other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. The second rule takes account of the fact that in a criminal case, the state should furnish proof beyond reasonable doubt. As I understand the state case is that Mr. Zuma had been negligent in driving at a speed of between 90 to 100 as per his estimation when there had been a sustained period of rainfall and possibility of localized pooling forming on the highway. It had been testified by Mr. Zuma that he hit a puddle of water formed as a result of water running across the highway, and as a result he lost control of his vehicle and veered to the left and hit the vehicle. There is no evidence on record to show at what speed he needed to have reduced his driving speed in order to avoid aquaplaning and therefore collision with the minibus. In terms of the dictum in Bloom, there is no way on the proof facts that the only inference to be drawn as to what difference any speed reduction would have made. This is based on the evidence of Mr. Van Logeren, Mr. Kuonje, as well as Mr. Luther. All the three witnesses testify that aquaplaning could happen even at low speeds. The joint minute captures the essence of the evidence as follows, and I quote, "Research shows that there is no precise equation to determine the speed at which a vehicle will aquaplane. In other words, it is near impossible for a driver who is confronted with heavy rainfall to know what will be the safest speed to travel to avoid aquaplaning. The reason for this is that the driver will not know the depth to which water has collected at certain places on the roadway, nor will he or she always be able to observe how widespread over the roadway the water had collected, particularly where visibility is impaired." End quote. The conclusion contained in Exhibit O doesn't support drawing of a negative inference on the part of Mr. Zuma, and indeed Mr. Dlamini, who also drove at the same speed. The court can return to the four instances that the state indicated it was relying on as instance of negligence in response to a request for further particulars in terms of Section 887. In doing so, the question is whether evidence has shown that to be the case. There is no evidence that indicates that he failed to keep a proper lookout. I accept the defense argument that none of the evidence presented established that there was anything that a reasonable man in the position of the accused on that night would have foreseen. It is so that all the evidence shows that there was unforeseeable puddle of water on a national highway and that a reasonable driver would not have been able to see it in the circumstances and inadequately take any action to avoid it. The accused was driving a roadworthy car, and the issue in regard to the condition of it is neither here nor there, as was belatedly argued by the prosecution. It has been established independently that the tires were within the legal limit of 5 centimeters. He was driving at approximately 90 to 100 kilometers. The other road users made the same determination that that same speed was reasonable in the given circumstances. There is no evidence to suggest that the accused firstly should have foreseen the presence of a puddle. The other two drivers didn't see the puddle of water, but we know that when the passengers alighted the minibus after the collision, the water was angled high and covered their shoes. And secondly, there is no evidence to indicate what step he should have taken to guard against aquaplaning. And in particular, no evidence is available to the court to find that the speed to which it might have been set a reasonable driver would have had to reduce his speed in order to avoid what eventually happened. It is therefore found that the state failed to prove the case against the accused beyond reasonable. The version of the accused is found to be reasonably possible true. The accused is found not guilty both in the main and the alternative count.
Sakho